And Jeff?
She almost
I
forgot.
you up. You okay, gentlemen? Can you all hear each other?
I can hear you.
Here I am.
Hey,
Hi.
Aaron, how you doing? Thanks for joining us.
Thanks for joining. This is Jeff.
This is Jeff, and I'm here with Jason.
And you've got Jason right here.
Hi, Jeff and Jason.
Thank you so much for joining us. We will check. Laura, you ready to record on your end?
We are already recording.
Awesome. So Aaron will just do a little intro and bring you right on, and we'll get right into everything, okay?
Let's go.
All right, Jeff, here we go. So, Jeff, it's time to talk about NCAA amateurism, or what's left of it. The door to a new era of college sports officially opened yesterday. NCAA athletes are now able to make money from business ventures without losing their eligibility. Let's bring on legal analyst Aron Solomon to break it all down. Aaron, thanks for joining us to talk about this quick changing landscape.
It's really my pleasure to be here, and it is quick changing. It's not changing by the day or even by the hour. It seems to change by the minute now.
Yeah, and so I wanted to take a step back till we get to where we are right now, because about a week ago, the court came down with a decision. Everybody's talked about, should athletes be paid forever? Can you talk about the background of the Supreme Court ruling in Alston versus NCAA and what they said?
Let's use our football analogy here. In Alston versus NCAA, the court totally decided to punt. All they did in that case that came down last week is say that athletes can be compensated in academic ways. So they can get computers, they can get books, and these were things that weren't even allowed before. But they totally sidestepped the issue of NIL, and that's the heart of all this. It's the name, image, and likeness issue. In other words, the athlete's ability to monetize who they are. So that's what the Supreme Court said last week, and then it's been a real kind of whirlwind since then.
Yeah, and so the next step is all of these schools are left, unless the NCAA steps in, all of these schools, every university in the country has to figure out what this all means. Tell me what it all means and what the NCAA has done or hasn't done to fill the vacuum.
So we're going to stick in chronological order. So after the Supreme Court case last week, a lot of legislators that hadn't been doing things decided to get to work. And they said, you know what, we want to make sure that we've got legislation in place by July 1st around this NIL issue. Now, we also had states like New Jersey that solved this issue back in September, but their NIL legislation, I hope you're sitting down for this, doesn't come into effect for 5 years.
Having worked in New Jersey politics in the past, I'm not surprised by that at all.
Wait, so can we just to be clear, that means that most of the students who start this year, assuming they only go to school for 4 years, this won't even impact them.
Well, again, we're sticking in chronological order. So before last night, that would have been the case.
Okay.
And then what happened last night, and by the way, all these colleges saw this coming. So they started hiring NIL consultants 9 to 12 months ago to help them negotiate what they knew was going to be a morass. Then last night, the NCAA puts out this statement. And they basically said, this is the way I've been describing this statement all day today. The NCAA pointed in one direction and said, look, a squirrel, and then ran in the other direction. What they said was, any athlete can engage in NIL, name, image, and likeness activities that are consistent with the law of the state where the school is located. If they are attending a school where there is no NIL law, so New Jersey would be an example because there's no NIL law that kicks in today, then they can do whatever they want and they won't be violating NCAA rules. So really what the NCAA has done is create a huge mess where it's going to be a dynamic tension between the athlete and between the university as to what's okay and what's not okay. And a lot of the stuff is absolutely bound to end up in a variety of courts.
So I know that the answer is basically because they're the NCAA, but why did the NCAA wait so long to do anything about this? It's not surprising. Everybody sort of anticipated that it might go in this direction. And who's going to enforce these rules?
So I'll give you a little bit of a longer answer, but not much longer. I believe that the NCAA is just a dastardly organization. There's no kinder way to say it. The NCAA, to me, is on the moral par with Major League Baseball. I mean, it really is. These are just bad organizations. And the NCAA has realized that, this is going to be a no-win because they're either going to lose at the Supreme Court with another case or controversy that comes in front of them during the next term that starts in October, or they're going to try to gently back away as they did last night and say, no matter what goes on with NIL, we're going to stay out of it.
So what do you do? How do you enforce it? If you're an administrator from any school, what exactly do you tell the students and how do you enforce it so that you don't get sanctioned later on?
What's happened in the past 24 hours is these schools are reaching out to current and prospective athletes because you better believe that NIL is going to be used as a recruiting tool too. And they're saying, we're setting up with consultants and we're setting up departments and we're actually now going to help you monetize your image, also help monetize it for the university. Universities are great at doing that, right?
Mm-hmm.
So there was an example a few days ago. There was an awesome ESPN piece that came out before the NCAA's decision where they took a deep dive into what was going on in LSU. And earlier this week in Louisiana, the governor said no athlete is going to be allowed to, advertise beer. And I was saying, okay, well, that's great. But what happens if the athlete's 21 years old? What happens if that athlete wants to give their name, image, and likeness to a roadhouse that's known for barbecue, but also sells beer? You've got a lot of athletes who've been announcing since last night that they're open for business. And we can certainly go through some of the names of the highest level athletes out there. They are going to remarkably well monetize their name, image, and likeness.
Before we get to the individual names, I wanted to stick on the what they can and can't do, because University of Illinois came out with their new policy, which requires athletes to show any contract to the school valued at more than $500 prior to signing, prohibits adult entertainment, sports betting, gambling, cannabis, vape products, and alcohol. How can they restrict that based on this ruling? I mean, haven't they lost the ability to restrict what these athletes can and can't do with the decision if they're allowed to use their likeness?
Well, because I don't have the Illinois statutes in front of me, and that's the only thing that matters. So if, for example, it would be illegal in Illinois to advertise cannabis, then it's fine that the University of Illinois says that. But everything that you just read from the University of Illinois has absolutely zero legal weight, unless they're just basically saying what a statute already says. The universities can say nothing. The universities can try to say whatever they want. All of these top athletes, by the way, have also in the past week hired their own NIL consultants, and they've got lawyers and agents giving them advice as well. So that's something, all these things are heading to court. The schools are going to say, don't do it. The athletes are going to say, sorry, doing it.
Well, so what you just mentioned lawyers and agents. So when you are an amateur, and I'm using air quotes, you're not supposed to have an agent per se. I guess you can have a lawyer if you have something else to do. But now you've opened that can of worms too, because they should be entitled to have lawyers that are negotiating these deals and making sure they're corrected or protected. What do you do about that now? And second, what do you do about boosters?
So the NCAA solved this last night when they were running from the squirrel. Their exact words were, individuals can use a professional services provider for NIL activities. So we can all define professional services provider, lawyers and consultants.
So they're now allowed to have agents.
Wow.
They're allowed to have professional service providers.
Okay. Well, you and I both know what that means.
Yeah,
So
sure do.
Explain to me, how is this disparity between state laws going to be addressed? Because then you have the unfairness of students in one state being able to do one thing, students in another state doing another thing. Is this Congress that has to act with the legislation that's there? Is this the NCAA that's going to come out with a policy? And do they even have the teeth to enforce a policy?
Neither of the two of them are going to do a thing. There have been 9 pieces of federal legislation that have either died or in the process of dying, including one a few months ago from Cory Booker, to deal with NIL on a federal basis. Of course, it would make more sense if there was federal law that governed all this, but it's going to be up to state law. And as I said in the beginning of the broadcast, this is why this is going to be both a competitive and comparative advantage and disadvantage in recruiting. And it's not just going to be state by state. I was on sports radio in Syracuse the other day, and we were talking about, let's say you've got a basketball player from New York City, and they were considering somewhere like Iona or Fordham. And then Syracuse says, what are you going to go to those schools for? You think you're going to make money off your likeness and image at Fordham University? Come to Syracuse. Everyone here's a basketball god.
I don't know how they now keep boosters out of this. Boosters could now sit there and say, okay, if you decide to sell your likeness on a book, a booster can just now buy 1 million copies of the book, right? I mean, you can't stop them from doing this now.
Well, what about you? Of course. The answer is of course. A lot of boosters have things like car dealerships. So people have been asking me a lot the last few days, well, doesn't just this mean that only the top name colleges are going to get top players?
Nope.
Well, yeah, but I mean, like, how many basketball players at Carolina are going to do a great job monetizing their name, image, and likeness? It would make sense that maybe one of those players goes to a school in another community where the number one booster there owns a car dealership, and then this student athlete is selling Fords and getting some really nice money and probably some nice Fords. Remember, the NCAA included athletes, recruits, their families, and member schools. So I'm thinking there's multiple Fords involved in that deal. And instead of playing at Carolina, this person's playing at a smaller college and is the absolute number one brand at that college.
Well, and remember, in the digital age, it's not just about a booster. They can go on Cameo now and sell themselves. They can strike deals as influencers on social media. I saw the twins that struck a deal and then tweeted out a picture of them on the big board in Times Square yesterday. It's a fascinating case of where these players go. I saw one athlete who said he can now actually perform with his real name and get paid to perform songs. He sings country songs, which he wasn't able to be paid earlier. So does this lead to athletes?
Is he good?
I guess we'll find out. Does this lead to athletes who aren't those top stars that are guaranteed, but athletes on that next level sort of staying in school longer because there's a financial incentive for them to be there where there's more of a risk coming out?
Yeah, so it's going to really be a question of sport by sport. So if we look at basketball, this is not going to change the one and done. And in fact, I believe part of the pressure for the NCAA doing this comes from things like G League Ignite, right? You've already got, as of this past year, high school kids graduating and making $100,000 a year playing on a special G League team. And if you look at the projected top 8 picks in this year's NBA draft lottery, half of them are going to come from the G League Ignite. So with that, then you don't even have motivation to go to college. At least this way, there's motivation for someone to spend a year at Duke rather than a year with Ignite and cashing in that way as well. Otherwise, you could make $100,000 a year with Ignite, or you could go to Gonzaga and you're hopefully going to get enough calories in the day. There are still athletes, today going to bed hungry at night.
All right. I'm going to ask you a quiz question now. How do you now define amateur?
I could never define amateur. So, how do I define amateur? I would define amateur as someone who has an intention of participating in Olympic Games, and you have to adhere to the IOC definition of amateurism, because any NCAA definition of amateurism is off the shelf. And of course, if we want to talk about hypocrites, look at the IOC. Right? The Olympic Games are for amateurs. The last time I checked, there's a lot of sports where everybody is a highly paid professional.
So how does this jibe? So how does this jibe? What if you're a college athlete and you're a swimmer at the University of Maryland and you use the NIL rules? Does that put you in jeopardy of any amateurism as it relates to the Olympics?
I believe so, and that's again something that the courts are going to have to solve. Right. And it's one thing, again, let's look at Spencer Rattler, right? He's the Oklahoma football quarterback. He became a national name when he was on Netflix QB1. He doesn't have a ton of followers. He's got 400,000 Instagram followers and 62,000 on Twitter. Compared to a lot of other college athletes, that's not a ton. But his face began to become recognized when he was only in high school. So he's going to be able to easily monetize that, doing whatever he wants, whether or not he wins the Heisman. If you have someone in a sport not like football, not like Division I, but something like rowing or tennis or whatever, it could keep them in school longer, but could also jeopardize their amateur status depending on what they want to do next.
So, we're talking about the amateurism side of this, but the court also mentions a few times the MLB antitrust exemption. Jeff and I have covered baseball a lot. We've done a minor league show, covered the minors extensively and the conditions that those players are under. Can you talk a little bit about what they said about the antitrust exemption in this part of the ruling?
It was so interesting because I follow baseball super, super closely and recently wrote a piece about the treatment of minor leaguers and how this has to change. So what they took a real swipe, the Supreme Court did, at Major League Baseball in this NCAA ruling. They were saying that the NCAA is fundamentally and deeply anti-competitive. And then they said, oh, and by the way, so is baseball. They were, I'm paraphrasing here, of course, but they were kind of saying it's remarkable that baseball's antitrust exemption has lasted a century. And I think they were giving a very clear warning that with the right parties and the right case, that they're going to revisit the antitrust exemption as early as the October 2021 term. And of course, baseball has another thing going for it, which is the Save America's Pastime Act. And that's specifically the reason. That's 2016 legislation. And that's specifically the reason why minor leaguers are paid minor league baseball does not have to pay minimum wage and does not have to pay overtime. So you've got people in certain organizations who don't get paid for extended spring training, don't get their hotels fully covered, don't get a housing stipend, and you've got minor league players making $750 a month.
Yeah, we've actually seen some of these minor leaguers probably get paid less than the concessionaires. So the question is who exactly would be the right party to go after Major League Baseball?
That's such a good question. So, it's funny because the NCAA path was really a circuitous way, given the fact that we're talking about NCAA athletes, to look at baseball's antitrust exemption. I also want to say it's pretty clear that it's not going to be legislators who are going to take care of the baseball antitrust exemption. They might put a stick out every once in a while, like the Republicans did around the All-Star game, but they're not going to do anything. I think it would be an aggrieved party who has, for example, played low-level minor league ball, unlike the Bryce Harpers of the world, who not only make $24.7 million a year, but had a signing bonus when they began rookie ball.
Right.
I think somebody like that to be able to show, because you got to think about what do you have to do to get in front of the Supreme Court, right? You've got to be able to show specific harm. You've got to be able to show that you were injured. You've got to be able to have a specific redress. I think that there could be somebody like that who ends up coming through, and there are cases like that, I'm sure, right now, weaving their way through the district courts and the appellate courts. And the thing is, we've got to remember this, guys. This is a 6-3 conservative majority. And if we would have talked yesterday, I would have said they were a very surprising court. They're less surprising today with what they did with the Voting Act in Arizona, which, again, is pretty dastardly, in my opinion, to use that word again. But nonetheless, this has been an unpredictable court. And if they find the right party, they could absolutely tear down the antitrust exemption. And then Major League Baseball, a very, very profitable business, is in a world of hurt.
But is it your impression that through that opinion, they were actually inviting or asking somebody to bring that case before them?
Yes, 100%.
That's what the text looked like. It said whether an antitrust violation exists necessarily depends on a careful analysis of market realities. If those market realities change, so may the legal analysis. They basically begged them to come before and challenge it. So I'll ask you my last question. What's next for both the NCAA and for baseball? Are we just now in the wild, wild west?
Well, the NCAA, we're so in the wild, wild west. In fact, when you look around, all you see is money and tumbleweeds. So that's the NCAA. That's easy to deal with that one. Baseball, I'm sure, is sitting in the same kinds of meetings that the NCAA has been sitting in for about a year, saying, how are we going to protect the kind of profit that we're making? And I hope that people in that baseball room are saying, why didn't we just treat the minor leaguers better before? This amazing organization called Advocates for Minor League Baseball, they've been fighting for a while just for a $15,000 a year salary for minor leaguers. They're not talking about massive signing bonuses, and baseball hasn't budged on that. One other thing, guys, you know what today is, right? Today in baseball, it's a very special day.
No, don't say
Bobby
it.
Bonilla Day.
Oh.
Right.
Do
And
you?
should we tell people what Bobby Bonilla Day is?
Jeff,
No.
Hasn't
You,
played in 20 years.
Jeff, you
And
just
you know what the
stumbled.
Mets paid him today?
$1.2 million, $1.7 million.
so I have to tell you, I literally sent Jason. We go through this every year, and Jason wakes me up in the morning with his Bobby Bonilla Day stuff. And I sent him a text. I don't know if you and Jason talked beforehand, but I literally said to him this morning in a text, if you text me anything about the Mets or any contract they had in the past, present, or future, I will block you for 1 week for each offense.
And the best part of it is,
and you brought it up.
I haven't been able to say anything yet, but the beauty of this year is the Mets and Bobby Bonilla have finally embraced Bobby Bonilla Day. Bobby Bonilla is out with a TV ad for a mobile phone company, and the Mets are offering a giveaway to be with Bobby Bonilla at the Mets Stadium. So for all the people who are talking about the Mets contract, they're actually getting a use out of Bobby Bonilla now. But well done, Aaron. I appreciate you going there.
And Jason, it's like the dam broke. Like Jason, all of a sudden this stuff came flooding out that I made him repress for half a day.
You're welcome.
And here's the thing. This is all fun. Listen, we love the Bobby Bonilla thing, but here's the reality.
No, we don't.
This is a tweet today from the Advocates for Minor Leaguers. They said today the Mets are paying $1.19 million to Bobby Bonilla. By the way, he's going to earn this money until he's 72 years old. But they said they still haven't agreed to pay back pay to current minor leaguers who've gone 9 months without a paycheck. That's the reality that minor leaguers are living in today.
Which is just unbelievable and unacceptable. And it will be something to watch going forward, whether the court takes something up and what the next steps are. Aaron, we really thank you for the time and breaking it down. Look forward to maybe talking to you again about this stuff.
Anytime. It's been my pleasure, Jason and Jeff. Thanks very much.
Thank you. Aaron, that was great. Thank you very much.